Yeah, thank you so much for joining us, everyone. Really appreciate it. Delighted to welcome Naomi Korn of Naomi Korn Associates, here to talk to us today all about copyright as creators, and going to talk through some vital knowledge in order to control your assets. So without further ado, Naomi, do you wanna take it away? Introduce yourself and what it is that Naomi Korn is all about.
Thank you so much, Leah. Thanks for having us, and thank you all for joining us. What is actually a very wet early summer's day. So, so I set up and run a company called Naomi Associates, and we're going to be celebrating our 23rd year in business this year. One of the reasons for our longevity is simply that we got on the copyright bandwagon before anyone else did. And we also took on data protection. So the company's grown over the last few years, particularly. And now we support a number of organizations across the UK and also internationally navigate those kind of fairly tricky areas of copyright and data protection. So we do a lot of work with cultural heritage organizations, lots of work now with Ukie. We work with young creators, young artists. We also work with publishers. We work right across the kind of broad ecosystem of kind of content. And so our, I guess, unique selling point is that we're not lawyers, we are practitioners. We're management consultants, and we integrate copyright and data protection compliance and exploitation of rights into organizations' policy frameworks. We help them develop their strategic objectives. We help train staff, and we are the guys that sort of do all the nuts and bolts, the kind of crossing the T's and dotting the I's to get from where they want to with content into actually making it a reality. So there are a number of us who work as part of the Naomi Korn Associates team, and a number of consultants as well. You can check us out by going to naomikorn.com. We have a newsletter. I'll give you a QR code to scan at the end of this webinar, and lots of free resources you can download and use for free as well. That's kind of that ethos of giving back, whether it's through webinars like this or conference talks or free resources. Thought pieces, thought leadership pieces are really, again, why I think we've been around for so long. But today, I'm going to kind of quickly move into what we're actually going to be looking at. And again, sort of a little bit of reflection in that when I started along my career as a copyright specialist, copyright was a dirty word and no one wanted to know about it. It was the sort of dirty secret. And gradually, as we become more digitally connected, content developers in our own rights, content users, this amazing flow of kind of content globally, it's become an area where if you don't want to know about it, you have to know about it. And particularly within the gaming industry and the creative industries, it becomes really important to understand it, because not knowing about it can mean that it can affect your very livelihoods, and it can also present risks. So I've kind of cherry picked a few of the kind of from a wide range of topics that I wanted to cover today. So really setting the scene, what is copyright? And then so quickly moving into commissions and copyright, which will dovetail neatly into, I know, the fairly recent webinar on contracts that you've had. So we've been looking at that and sort of trying to tie it together a little bit, how you can use other people's works, and then really some top tips for protecting and enforcing your copyright. I'm sure you know how this works, but if you have any questions for me, please drop them in the chat box. And if I can actually address them live, I will, or I'll come to them at the end. So this is about giving you a chance to ask everything you always wanted to ask. I'm also going to make sure that I do cover AI and copyright. There are lots of dimensions here, but I'll try and summarize it. Before we do look at AI and copyright, so hold your horses just for a little bit, I wanted just to set the scene and kind of give you a broader overview of why you need to know about copyright, why you need to stay on and listen to this. So this is all about making sure that you understand copyright so you can protect your rights in your work. So whoever you are, whether you are publishers, whether you are game developers, By understanding copyright, you can understand what it means to hold exclusive rights, what it means to have rights either transferred to you or what happens when you transfer your rights to other people. You need to understand copyright because this is actually about making sure you understand how you can use copyright as a tool to monetize your work, whether it's through licensing or sales or royalties. It helps you as well understand that by having that kind of framework of copyright awareness, you can negotiate a fair price and fair contracts. You can understand the terminology, and this is so important. I've mentioned contracts and collaborations again. By understanding your copyright, you can avoid infringements. So you can make sure that you use other people's stuff legally, but also you get a better sense of, well, what should you do if someone else uses your content that you spent time in developing? What are your rights? The digital kind of stratosphere in which we operate, and this, again, the automation, the ability to use content anytime, anywhere, means that understanding copyright can help you navigate that space and navigate different digital platforms. It can help you become as creative as you want to, but also safe and compliant. It can help you manage your digital rights and protect your works as well from online piracy. I spoke about contracts, but collaborations are the name of the game, and we're learning this more that we engage with Ukie and its members. This isn't about people working on their own. We all need to collaborate. We need to work in partnership, and actually within, again, this sort of symbiotic space between game developers and publishers. We need to ensure that we understand those relationships and we understand the terminology used in contracts. And finally, the morality and ethics of using other people's stuff and people using your stuff in the right way. So understanding copyright can help you get a better sense of that. Now, within this bigger picture, copyright isn't the only intellectual property right you are likely to come across. So very broadly, those of you perhaps who know less about intellectual property, and here I can already weave in AI, intellectual property as it stands is all about the fruits of the human mind, okay? Human being the key word here. Now, despite all the mumblings and rumblings about AI, the World Intellectual Property Organization, WIPO, is very set in the trajectory right now that intellectual property rights can only protect things that are generated by human beings. So anything that's purely AI generated, for example, a fantastic picture perhaps that has been generated using artificial intelligence, maybe something you've programmed into chat GPT to generate, that cannot be protected by intellectual property rights, by copyright, if it is purely generated by AI. And the same would go for other members of the intellectual property rights family, such as patents. There have been applications for patents that have been generated by AI, and these have been rejected. Now, back to the intellectual property rights family. Intellectual property rights can be bought, they can be sold, they can be licensed, just like property. So if you own intellectual property rights, you have an intangible asset. And again, this is why you need to know about intellectual property rights, why you need to know about copyright, because copyright arises automatically with regards to works or original works that are your own intellectual creation. And understanding that automatic right that arises, so within the copyright sphere, enables you to control it. If you don't understand that it's arisen, then it's potentially lost, or you could lose those rights. Other rights that you might come across within the intellectual property rights family, within the gaming sphere, are trademarks. There may be either existing trademarks, or you may be part of a broader family, a broader organization that owns trademarks itself. I've mentioned patents, performers' rights, which can, like copyright, arise automatically, attracted to original performances, for example, in music, in sort of theatrical performances. So performers have those rights. And you can see here as well, design rights are notable. So these are the rights to protect something's eye appeal. So again, there may be within anything, if you are a game developer, perhaps there may be aspects here beyond copyright that you hadn't thought about. But again, starting to weave in thoughts about where copyright comes from and its relevance today. Well, actually, copyright is very, very old, and it goes all the way back to 1709, the Statute of Anne. It was originally lasting only for 14 years, but over the centuries has become longer and longer and longer in duration. And today, copyright generally lasts for someone's lifetime plus a further 70 years. So in as much as copyright is an important asset to understand and how it arises, it also lasts for a very, very long time. So it truly is an asset not only that will belong to you if you've retained your rights, but potentially can be passed on to your next of kin for that entire 70-year period. Copyright has had a sort of a long and checkered history over the years, but certainly as sort of, if you like, the world has become more connected, there's become a greater push to make sure that whereas the first Copyright Act in the world, the Statute of Anne, was unique to the UK, copyright today exists in most countries by virtue of international trade agreements and conventions, and therefore even if you're working with game developers in other countries, there is a very, very strong likelihood that they will have a very similar set of principles underpinning their copyright legislation. The difference we see really, I guess the most substantive difference actually is enforceability. So whereas the UK, I would say, has a pretty sort of high level of enforcement and adheres to the principles in the legislation and it's policed and enforced, there are other countries where culturally, perhaps, there's a sort of disjoin between culturally maybe copying seen as an act of reverence and actually a celebration of something being created. And therefore, that can be at odds with almost the country's legislative framework in the enforceability of copyright. So, just to name a couple of countries where we're very conscious of this happening is India and China. Now, it might be again that you're working collaboratively with co-developers in these countries, and sometimes it can be challenging, whereby we, as sort of generally speaking, as a country, adhere to copyright laws, actually how that sort of plays out in international collaborations. So again, a reference back to what I said earlier about actually we're talking today about building your knowledge in copyright, but very quickly you can see this isn't just about copyright literacy. This is also about contract literacy. And the two sort of dovetail together. So in those sorts of scenarios where you may be working collaboratively with game developers or publishers in other countries, contracts become the tools to lay out the copyright framework, the relationship between different entities. So having that understanding of copyright and also contracts simultaneously becomes fundamental to making sure you know where you stand with regards to copyright, who owns what rights, etc. So today, copyright laws have evolved. We have the Copyright Designs and Patents Act of 1988, and just again, an aid memoir, and broadly speaking, key principles I want you to remember. We've already spoken about sort of the concept of originality, so something being in a creator's own intellectual creation. Now that can be challenging if, for example, you're how far are you inspired or how far are you copying someone else's stuff? And this generally gets played out in sort of the courts. So the bar of originality is pretty low in the UK's legislative framework. But other sorts of aspects of copyright law is that copyright arises automatically. It does not require registration in the UK. And it is, as it says, it's an exclusive set of rights with regards to your right to be able to copy something, your exclusive rights to copy, to issue copies to the public, communication to the public, performing, renting, adapting, and you also have inherent commercial rights within those works as well. So here I kind of want to weave in another dimension about AI because it's actually a very complicated space. I sort of had a quick catch up with Leo just before. So here I'm going to weave in ChatGPT. Now, what does it mean if you use something that has been generated through ChatGPT? Well, ChatGPT and generative AI is trained upon people's stuff. It's trained on images, it's trained on text that other people have created. So if you are using ChatGPT, you ask ChatGPT a question, it will draw on the stuff that's it's being trained on, the sort of the humongous terabytes of content that it has access to. And therefore, although I said earlier that AI cannot own copyright. However, if you are reutilizing content that has been created through ChatGPT, through a question you've asked or an image that you've asked it to create, there is a very, very strong likelihood indeed that not only will it be using and recapitulating and regurgitating content that other people have created, other people's copyright works, but in addition to that, there are very strong likelihoods as well of plagiarism, whereby you may, if you were to use that content, inadvertently plagiarize, so use something that someone else has created without due attribution, or beyond that, using concepts or ideas that other people have already come up with. Now, an example I can give you, and this is sort of fairly ironic. A few years ago, I co-authored a book called Information Law Compliance, and checking through the sort of the text checker for AI, it's come to my attention that my information law compliance book on information law compliance has been ingested by one of the generative AI platforms. And therefore, if you ask a question relating to information law compliance, it may, there's a strong likelihood it will be regurgitating text that we have written without any attribution to us and without any authorization. And that's a sort of live example of how generative AI works. Now, it's a word of caution for you if you are using that within your game developing, within any business associated with what you're doing, to be mindful. But there is, I think, also a strong ethical component here. And this is obviously hotly debated at the moment, which is really to use other people's stuff in a way that you yourselves would be comfortable if they were using your stuff. And I know that from a from a personal perspective, actually one of the things that I find most important to me is actually being credited, giving credit where credit's due. And I think not only is that an attribution aspect, but that's also about a very strong, I think, ethical dimension here. So to be mindful when you use these generative AI platforms, the implications, the risks, the more commercial you use stuff that's generated through generative AI, the greater the risks for you, but also being really careful about, what does this mean for you as a business, as an ethical business, as perhaps a values-driven business? And again, it brings, I think, knowing how you can protect your assets, knowing how businesses operate. It's everything you do as a business needs to reflect your values. So sort of drawing those themes in, I think, becomes important. Now, the other side of AI that I just, again, wanted to just bring in here are the government's proposals at the moment. So some of you may have been aware that just before Christmas, the Intellectual Property Office issued some information about an active consultation looking at the relationship between AI and IP. The consultation closed in February, and it was actually one of the most successful government consultations. I have been told, again, this may be hearsay, but I've been told that the volume of responses to the AI and IP consultation of 11,500 is greater than the number of responses to government consultations on the smoking ban in pubs. This may be hearsay, but it just gives you a sense of the strength of feeling. Now, what the government is proposing is they're proposing a change to the copyright landscape whereby there's a removal of restrictions on text and data mining. At the moment, it's very restricted to non-commercial research, but one of the government's proposals is to open up the text and data mining exception to enable text and data mining for any purpose, with an opt-out option for creators. Now, this is very interesting because this really brings into sharp relief actually the balance that copyright's trying to achieve. On the one hand, to protect creators' rights, but on the other hand, to enable access to knowledge. And this is always a sort of push-pull balance that we see across the copyright landscape. But within the AI and IP consultation, it's really playing out because you have on the one hand the sort of research institutions and AI companies who want access to content, see this as being a benefit to the digital economy, see this as actually driving growth for UK PLC. But on the other hand, you have the creators, and you may have been aware of Elton John's responses to the UK government calling him effectively criminal for their proposals, and the Make It Fair campaign by a number of artists and their release of an album that had nothing on it. And they're adamant that this proposal will actually undermine the creative industries. Ukie and the members that it represents, I think, are kind of stuck twixt and between, because I can see the huge benefits for the gaming industry in opening up the text and data mining exception as a result of the AI and IP consultation, but also you as creators. I can see that there may be challenges and there may be issues. Now, back last week, I chaired a conference that had a large component on AI and IP, and we had a government official come and give us an update about where things are at. I mean, as you can expect, she didn't actually say that much, but it is a case of watch this space. And what we do know is that government is consulting wide and far about this change to the UK's copyright legislation, which I think will be a game changer. I think if government moves the bar and this exception to copyright, the text and data mining exception to copyright is widened out, I think it's going to be fascinating for people who use other people's content or who want to ingest vast amounts of content, process it, and find patterns or create new creative works based upon the research that's drawn from this analysis. But it will also be interesting for creators. So I can't really say more than this right now because I don't know. We're watching this space. Naomi Associates will be going full on in releasing information about the response, the government's response to this consultation, where they decide to go to next, and what the impact may be for you guys. Please watch what we're writing. We'll make it as accessible as possible. We'll send it down all our channels, our newsletters, our blog posts to keep you informed about the practical implications for you. But it is a big case of watch this space right now. Okay, so one of the reasons why knowing all about copyright is important is it's not just a one-trick pony. It actually covers an awful lot of content. There are many different types of content that copyright protects. So inherently, there are 8 categories of works that copyright protects, ranging from artistic works, so that could be graphics, that could be photographs, that could be images of artworks, that could be paintings. Again, don't forget, with a human creator. There could be digital gaming elements. If you are interested in my views on digital chickens, there's a Ukie webcast Q&A that I did with Leo a couple of months ago, where I speak all about game developers and chickens and the marvelous stuff that I see in terms of the kind of artistic works that game developers create. There are also text-based works, moving images, music. Now, music could be music within a game that's either made specifically for the game, or it could be music that already exists that you use under license from a third party. Dramatic works, anything comprised of sort of or consisting of performance. Typographic arrangement is layout, recordings of sound, recordings of music, sound effects, etc. So very broad church of works that copyright protects. I've got a note here about website cookies. Now that actually is that's interesting because website cookies is obviously covering privacy rights. So that's more about data protection, which we also do as well. But I agree, and this is to do with the data protection legislation where there's a requirement to opt in. So consent has to be actively given. We're talking here about the AI and IP changes to the copyright legislation rather than the data protection legislation. But I think, Lance, your question's a really good point because actually it's the ethos behind it. And I can tell you that the reason why government is even entertaining an opt-out over the changes to the text and data mining exception. So these are just measures that are being considered right now. The reason they're doing that is because of Brexit, because when we were part of the EU, it wasn't possible to even consider this because of some EU case law. When we left the EU and we moved away from EU case law, and it created a space where we could consider the opt-out. Okay, so there's a lot here entwined. Copyright lasts for a very long time, as I said, and you'll gain access to these slides, but generally speaking, lifetime plus 70 years, and then it can vary according to the type of work. Okay, so you've got just sort of a heads up. So, copyright, you need to know about it if you're creating stuff, to understand the rights that you have, the control you have over your stuff. Okay. You need to understand copyright if you're using other people's stuff. You need to know how much you can use of their stuff. You need to understand their rights. And again, we speak about the ethics here. You need to understand what the law will allow you to do. And I will touch on this. But another thing I want to bring in, and it's often forgotten, are moral rights. So moral rights are a thing. They're built into the Copyright Designs and Patents Act, but this is actually about your relationship to what you've created. And if you're using other people's stuff, their relationship to what they've created. It's, in a way, it's like the ethical backbone of copyright, because it's all about someone having the rights to say, look, I created this, it's mine. And also they have rights to control how what they created looks. So the object itself, the thing itself, the digital thing itself, but also if it's changed or altered by other people, they have those rights. Now, this came from the continent. It was inherent within France and Germany before we got it in the UK. But please don't forget your moral rights. Please remember that if you are, again, in a process of negotiating with a third party, with a publisher, with another entity about perhaps taking what you've done and sort of building it into something else, protect your moral rights, because whilst copyright cannot be waived, moral rights can be. And it's those little clauses in a contract where you might be required to waive your moral rights. Once you waive your moral rights, you give up the right to be named, you give up the right to control how your work looks. So make sure you retain your understanding of moral rights. Okay, so I've got a slide here for you. Okay, so just these are your moral rights. Okay, it's that kind of really strong connection you have to your work. As I said earlier, these are what I think are hugely, hugely important. So let's move on a little bit. Commissions and copyright. So if you're commissioned to create something for someone else, what you would expect to get is some kind of agreement. Okay. And the reason is because if you are an employee, if you're being commissioned to create some content on behalf of someone else, whilst employees who generate content, it'll be the employer who will own the copyright. If you are being commissioned to create something for someone else as a freelancer, the default is that you retain the rights unless there is a contract in place and unless the commissioning party requires you to enact something to do with copyright. So understanding what rights you have when you're commissioned, what rights you retain becomes important for how you control and how you protect your rights. Now, there are a number of things within that agreement that I've just kind of flagged up for you because I'm wanting to kind of make sure I give you enough information. We'll have some really solid time for questions. When you transfer your rights to someone else, in England and Wales, we would refer to this as an assignment. In Scotland, it's referred to as an assignation. So it might be, for example, that you're commissioned to create, I don't know, you're a game developer, you're being commissioned to create forests. Okay, that's your thing, right? You're very good at creating these incredible forests. Maybe it's a dinosaur game and there's dinosaurs kind of stomping through the forests and through the undergrowth, but you're the one that develops those forests for the dinosaurs to stomp through. As soon as you assign your rights to someone else, you transfer your rights, you no longer own those rights. Now, we often see in contracts that we look at on behalf of our clients, contracts that are actually sort of a bit of sort of belt and braces, whereby you may be required to transfer all your rights to a third party. and you get money in as part of this contractual relationship. But what we do a lot of work with our clients on is reminding them that if you transfer all your rights, so there's no differentiation between the rights that you create specifically, or the rights and the content you create specifically for your clients, as opposed to all the rights in what you have done that might include other elements that you already own, you could do yourselves a massive injustice and find yourselves giving away more than you should. So with any contract, we would expect to see a differentiation between foreground IP or foreground copyright, which is anything that you've done specifically for that client, and background copyright, which is stuff that you already have done before. Because let's be honest, as kind of creative people, we often have a style. There are elements that we repeat endlessly within what we do. And as a business, when we're commissioned to create stuff for clients, we'll reuse often elements that we've already done, that we've tried and tested, that we've built up over the years. Well, you'll be in a similar situation. So we would strongly advocate and strongly advise that in any contracts you have, that you look for the sort of, again, the devil's in the detail here, but rather than assign all your rights to that particular client, to make sure that there is a clarity between, yes, if you do decide to assign your rights, the rights in your foreground IP, but the background IP, stuff that already exists, you perhaps only grant that client or the third party you're working with a limited license to use, because that is the gold dust. That is the stuff that you already own. That's the stuff that could actually be detrimental if you transfer it all. But the other type of agreement that we see, so to be clear, whereas assignments are the tools whereby copyright is transferred from one party to another, licenses are the tools where permission is given. It's a bit like a rental agreement. So you own a house and you rent it out. You still own the house, but you allow certain privileges. A license works in the same way. So whereby you would still retain the copyright in what you do. If you are being asked to grant the third party a license, then you will still have, to some degree, the ability to control the use of your work. Now, here I want to wrap in some really important information that will allow you to sort of have that knowledge and confidence to negotiate what's in your best interest regarding copyright. Whereas, yes, in theory, a license means you retain the rights, the type of license you grant can also greatly affect how much you still retain in terms of control. So what you may come across in a contract is the terminology exclusive. Now, an exclusive license means that if you grant an exclusive license to a third party, depending upon the terminology in that exclusive license, it can, in reality, be as restrictive as an assignment. An exclusive license means that you are enabling that third party with whom you're developing the contractual relationship to use your work exclusively, and to the detriment potentially of you being able to use that work yourself and you being able to grant anybody else a license as well. Now, we see this throughout the creative industries. We see this throughout the relationships between creators and whether it's publishers, within the music industry, whether they're game developers, whether they're musicians, artists. The ability to control your work going forwards is only as much as you knowing about copyright, but also that you don't hemorrhage your rights to third parties through the contracts that you agree to. Now, we know this is a big issue, or an increasingly large issue for the gaming industry, but the devil, again, I've said this a few times, the devil's in the detail with regards to what you're willing to sign over. And so here we've got an aid memoir. We wanted just to give you a few key points here about what to be aware of, how you can protect your rights, how you can retain the rights in your assets. So being mindful that do you need to transfer your rights? If it's an assignment or an assignation that's required, is there a really big pot of money for you at the end of this that makes it financially worthwhile? Do you need to transfer your rights in perpetuity? Can you limit them to a number of years? Can you also have restrictive clauses that if you transfer your rights, if for whatever reason the publisher does not assert their rights over a period of years, that they revert back to you, so revisionary clauses? Second, do you need to waive your moral rights? Be really careful about not giving away your moral rights because you give away your right of attribution, and that might be detrimental for you going forward, particularly if you're a young creative wanting to make your name. Can you seek a compromise? So on a consent basis. So for example, instead of waiving your moral rights, can you perhaps seek from the third party the ability for you to be attributed where reasonably practical, or for your work to be changed or altered on a case-by-case basis? So instead of giving everything away, stagger the permissions. Are the rights that are requested from you more than is needed by the third party? Do they really need permission to be able to reproduce your work in every edition? Again, this came out of another webinar that we listened to. What about your rights in any sequels? What about your control over any derivatives? Do you really need to sign those away at that point? Is it worth the money that's on the table? So you need to do a cost, risk, benefit analysis. If something looks too good to be true, in my opinion, it normally is too good to be true. And actually, this sort of intrinsically ties, again, copyright, knowing your rights, to the money at the end. So it might be, rather than getting a large upfront payment, if your rights are required, and if you are giving away your rights over sequels, can you still build in the ability to not only get perhaps a smaller upfront payment, but perhaps a share of royalties going forward? So we've seen those sort of mixed and blended models as a way of protecting your rights, being more amenable. And here I've mentioned about shared revenues. So a few points here for you to be aware of, a few points here for you to protect your interests in contracts. But of course, this isn't the only thing that we need to know about in terms of copyright. It's also about how we can use other people's stuff. So of course, one of the first things to do is get permission, make sure that you understand if you have the necessary rights from third parties. And again, I spoke to you about the ethics of this. But I also want to give you a sort of an aide-memoire here, which is that there are some exceptions to copyright. So this sort of balanced framework in which we operate in, whereby there is, again, the exclusive rights that rights holders have over their works, but there are some exceptions that permit certain sort of limited uses of other people's copyright works. Now, there's a lot that I would cover if we had hours and hours to talk, and I'd probably run out of voice by then. But there were some changes to the copyright legislation back in 2014, which actually I think are quite interesting for the gaming industry. So I'm just popping this in the chat box. So there was a new exception that came in, and my spelling's appalling: parody, caricature, and pastiche. Now, this means that for those purposes, there is a potential of using a limited amount of someone else's work if what you're doing is a parody, a caricature, or pastiche. Now, this hasn't really been tested in law, but it might give you some respite and a little bit of flexibility. Now, the difference between the exceptions to copyright and getting permission is, yes, these exceptions are hot-wired into the legislative framework, but number one, ethics. Number two, they're not without risk because you're having to interpret what the law says. If you are operating in a risk-free environment where you're not willing to take any risks, perhaps there's high-value content here at stake, the exceptions are probably going to be less relevant for you than just going and getting permission or finding content whereby permission is already granted. And I'm sure some of you have heard of Creative Commons licenses, okay, where people effectively pre-program the license into the work saying you can use it for this, but not that. That is another option. But for those of you interested in exploring the exceptions to copyright, this is the best website I have ever come across, apart from our own. No, it really is a great website. It's called Copyright User. I'm popping this in the chat box now. Copyright User is a fantastic website, and it's really about um, giving everybody uh, as broad an understanding of the exceptions to copyright so you can really utilize them. Copyright Users is a collaboration from a number of sort of different universities across the UK, and they've got some fantastic animations where they really get to the heart of what copyright is from the perspective of creators. They also do a really nice little kind of parody of Sherlock Holmes, trying to kind of understand and unpick the kind of complex ecosystem of copyright. So do have a look at that. But that's a great way of getting your head around the exceptions to copyright and seeing whether they work for you. So we're kind of into this space where it's important that we understand copyright from all these different dimensions. There's lots here to unpick, and certainly if you're wanting to go on a more detailed journey with us to find out more about it, be part of a participatory, live, facilitated workshop, chat to other people facing the same issues, come onto our training courses. We've got a number of them we're doing in partnership with Ukie, where you can really get kind of a whole day or half a day with us. We'll work with you through the different aspects, whether it's you want to know about copyright basics, you want more on the exceptions to copyright, you want to understand commercial licensing, or maybe you want a whole half day on commissioning and what you can expect to find in there and some of those clauses. So there's lots. This is a bit of a taster for you. But I wanted just to give you just a few more slides just to kind of, if you like, whet your appetite, give you something back from today. So protecting your rights, okay? So just some bits and pieces from us. So if you want to protect your rights, you need to know what they are, okay? This is always about the line in the sand. When you're negotiating with a third party, if you're being commissioned, you're being paid to do stuff, you're working with a publisher, work out how far you're willing to go, okay? Work out what you're willing to give away. Think about the long term, okay? This isn't just about here and now. So many creators give away rights early on in their career and wish they hadn't done that, okay? Make sure that if you are working in collaboration with a third party, hold on to your ability to be credited, okay? That retains your rights, your profile. But likewise, if you're using other people's stuff, please credit. Now, we do a lot of work using content that's pre-licensed. So we go onto Unsplash and wherever we can, we credit the creators of those images from Unsplash, which is a free site with lots and lots of stock images, because it's the right thing to do. And if you are publishing content, lots of people don't understand copyright. So tell them what they can and what they can't do. You can use technology to work with you. You can use whether it's digital watermarking, fingerprinting, reverse image searching, find out how other people use your stuff. But also you can think about joining a creative collecting society like DAX that represent creators. Enforcing your rights. In as much as this is hopefully going to help you understand what you can do if someone uses your stuff without permission, be aware that this is what they can do back to you if you don't get permission yourselves. Okay, so it's a right back at you here. If you're enforcing your rights, you have the right to ask someone to take something down. There are organizations that can help with this. So you might have heard of ACID, anti-copying in design. There are also services offered by the Intellectual Property Office, the part of government that oversees intellectual property rights, and there is a whole process that they follow. There are lots of court systems as well, and you can actually be quite successful if someone is using your copyright work without authorization. There's effectively a small claims track that you can follow. You don't need legal representation. It works in a very similar way as to the small claims courts. But as I said, in as much as this is for you to understand how you can enforce your rights, and ironically, in the age of AI, knowing about copyright has never been more important. But this is what someone else can do right back at you. So some top tips from me, and then we'll take some questions. So just know what your rights are. You can never know enough about copyright. So go onto sites like Copyright User, read up about them. We've got fact sheets you can download from our website. Make sure you understand what your rights are. Make sure that if you're using other people's stuff, you understand if it is being licensed to you. If you find it on the internet without a license, assume you can't use it. Okay, only look at content that already has a license attached to it. And if it doesn't have a license on it, then it's about getting permission. Be polite, be kind, tell someone how you're using your work, negotiate if they ask you for too much money. That works quite well. Look at how you can protect your work, and that can be things like crediting. It can also be putting information to other people about how they can use it or not. So if you don't put information about how someone can use your work, assume other people are likely to use it, not because they're being malicious, simply because they don't know, they don't understand. So make that clear, signpost it. And finally, top tips from me, from us, read the small print of contracts. Okay, so words like irrevocable, exclusive, wavering, and moral rights, those can really be detrimental to you in the future. And if you need some help, we're here, we can help you. But there are also other sources of help and support that can guide you through this. We've got some details here again. If you've not caught this about copyright user, intellectual property office, and also we've got a guide here that we wrote, on a free guide available under a Creative Commons license, about copyright and working with suppliers. There's a QR code here if you want to receive the latest information from us. So we write a newsletter about once every 2 months, and as I said, we're going to blast it full of AI once the government makes up its mind about what it wants to do. So please do kind of keep in touch with us, and we often have offers and discounts. You also get, I should say, preferential rates by being Ukie members of our training as well. So do keep in touch. So I wanted to give us time for questions. I think that's to time. So anything you've ever wanted to know about copyright that I can help you with today?
Wonderful. Well, thank you so much, Naomi. That's really, really interesting stuff there, and pretty exhaustive. And you've included some links in the last couple of slides. So just to reassure people, we'll pop this on YouTube. I'll be sending you a link at some point, maybe in the next couple of days, and we'll make sure that those links are available in the description as well. So yeah, we've had a couple of questions in the Q&A box.
Right.
I guess some of them are possibly that you've already sort of answered, maybe along the lines of sort of the progress of the government in terms of updates to copyright law, specifically regarding AI, I suppose. I mean, do you have? I mean, we can't comment on this, but an idea of a rough sort of timescale from your perspective on when you'd expect to see some change afoot, perhaps.
It's a really good point. So government, when the speaker from the Intellectual Property Office was in charge of this consultation, and she gave very little indication when pressed about time. What she did say was, she intimated that government was quite surprised and taken back by the volume of responses to this consultation. I mean, to be honest, they normally get a few hundred. So 11,500 was an enormous amount of responses. And again, if you look at this, take a sort of bird's eye view here, with government, even government streamlines to civil servants, the civil servants we have in government, I think it's going to take them so long to work their way through it. So what we are seeing though is, I don't know if any of you have been watching this, but there's a data bill that's been working its way back and forth. It's a ping-ponging between the House of Commons and House of Lords at the moment, and there has been an amendment put into this data bill, which wasn't really about copyright at all, which is requiring AI companies to reference their sources. So that is an interesting development. And actually, sometimes we do see this in the legislative process, that you do see a kind of tag-ons to other pieces of legislation with regards to copyright. So that is something we do know. But again, that's ping-ponging between the House of Commons and House of Lords. So I don't know what's going to happen there. I really don't know how this one's going to play out. I really don't know. I was surprised that government has made the suggestions it made, also because a few years back it made similar suggestions that the text and data mining exception should be widened. Now, across the continent, there may be an indication of the type of direction of travel that UK government might be thinking about, which is that the EU actually has two versions of the text and data mining exception. One is for research and one is for commercial companies. So that might be the way it plays this one out. So it's not a kind of a complete change to our exception. So the answer is it truly is watch this space, I think.
Yeah, definitely. It's interesting times. Obviously, different. I guess different stakeholders have very different sort of ideas and opinions on this. So yeah, it's definitely one to watch. Obviously, we'll represent the games industry here as much as possible.
Absolutely.
To do
Absolutely.
Yeah, and I think as well, this sort of the only other question that we have here refers to sort of code and assets. So in reference to using AI to generate code or assets for commercial use, how does that affect copyright? Who owns the copyright? I mean, you've kind of sort of covered that question up front already. Perhaps that came in sort
Yeah.
of fairly quick.
So actually, I can see that, and I've also got a question here about some brief steps to take if someone who wants to use your music in film or TV. So I'll come to that one in a
Yeah,
moment,
yeah,
and
do.
thanks for that one. So yeah, so software and code. Let me just so in using AI to generate code or assets for commercial use, how does that affect copyright? The answer is it depends on where the AI's got that content, um, got the code or assets from. So in the case of any content or assets that have been developed and released under an open source software license or a Creative Commons license, there's a greater likelihood that that would be potentially okay to use for commercial use. But there are so many different variants of open source software licenses, and also there are the ramifications of using Creative Commons license material are great because the terms of a Creative Commons license, or there's some different flavors of licenses that actually the reality is that the usage terms will vary considerably between those different licenses. So actually the answer is to your question, it really depends. And I would say there's high risk here because you don't know where the AI has drawn from, drawn the code from or the assets from. So number one, there's risk because yeah, I mean it could be, it could be anything that's available on the internet under whatever license, or in being ingested by Gen AI. But the second thing is who owns the copyright? Well, it could be everyone and no one because you can have something that then is generated that is a little bit of lots and lots of different people's stuff. So it won't be the AI. It's really the answer. The AI won't own the copyright, but it could be lots and lots of other people who do. Or if it's so jumbled and so indistinguishable, um, it could be no one. So it won't be you, is the answer. It was generated by AI, or not right now, anyway.
That's a fair point. Okay, so do you want to sort of talk about the sort of film and TV or use of someone's music
Yeah. So
in film and TV?
if someone wants to use your music in a film or TV, it's about understanding what the usage is that they want to make of it. So getting a sense of whether it's for a single program or whether that program, whether that content might be syndicated or licensed. So what normally you'd see for film and TV is that they will come to you and ask you to sign um, a it could be a non-exclusive license, okay, fine, but it might be for the universe in perpetuity, all rights known now or forever in the future. And that is actually a really big permissions to grant. And if you were to sign that, you would want to charge, I would say, quite a lot of money, because that basically gives them the rights to use your music without having to come back to you again for subsequent sort of additions or whatever. So I would ask them what they want, and then I would actually look at that contract, dissect it, and if it's a particularly valuable asset for you, I would go and seek additional advice to make sure that you don't inadvertently sign away more than you should be. So those would be the steps that I would take.
Yeah, no, that's a very sensible choice there. So again, we might have touched on this a little earlier as well with
Yeah.
your own book. But what should someone do if their work has been sort of ingested or trained on AI
Um,
without their permission?
the reality is I don't think there's very much you can do. I mean, this is about individually, I really don't think there's very much we can do. But I think that what you can do is make sure that you are perhaps a member of a professional organization, a membership organization like Ukie, who can work on your behalf. I know Ukie does some fantastic stuff representing the interests of its members. That's part of the benefit of a membership. Depending upon the type of field in which you're in, there are also other professional organizations that you may be eligible to join, like the Author Society, the Publishers Association, just to make sure that collectively you have a voice, because they will have a sort of a permanent lobbyist who's lobbying Parliament. They will have strong inroads into government. They will have also more power effectively to be part of a collective. So I think it's difficult. I think right now there isn't really an opt-out, but again, that might be potentially the benefit of change the legislative framework, which is offering us the opt-out. So at the moment, we don't really have that. But if this particular change does manifest, on the one hand, I can see the challenges, but there may be then the opportunity. So what am I going to do about my book? There is absolutely nothing I can do about my book being ingested by AI. I can't see, apart from the fact that I am a member of I think the Authors Licensing and Collective Society. So I could maybe I could chat to them, maybe see if there's any help they can offer me.
No,
Interesting.
that's
Thank
all.
you.
That's very fair. Okay. Well, thank you so much, Naomi. It's been really, really fascinating having you talk to us today. Really appreciate it. I'll make sure we have all the links. We'll make sure we have all the links that you've mentioned on the video on YouTube as well. So that's really, really good. Yeah, I just want to say thank you so much, and thank you to everyone that's come along. It's been really, really interesting and important. So yeah, thank you.
Thank you. Thanks, Leo, and thank you so much, everyone, for participating in your questions as well.